The Family and Medical Leave Act, or FMLA, provides crucial protections for employees who need time off for medical or family-related reasons. But who exactly is eligible for FMLA? And what are the requirements for both employees and employers? FMLA eligibility hinges on three main factors. First, an employee must have worked for their employer for at least 12 months. These months don't need to be consecutive, but any breaks longer than 7 years are not counted, except for military service. Second, the employee must have worked at least 1,250 hours during the 12 months before taking leave. This is roughly equivalent to 24 hours per week. Finally, the employer must have at least 50 employees within a 75-mile radius of the employee's work site. This last requirement doesn't apply to public sector organizations. One of the key protections offered by FMLA is job security. Eligible employees can take up to 12 weeks of unpaid leave per year without risking their position. When they return, they must be reinstated to their previous job or an equivalent position with the same pay, benefits, and responsibilities. Employers are also required to maintain the employee's health insurance coverage during their leave. FMLA leave can be taken for several reasons. These include the birth or adoption of a child, caring for a newborn or newly placed child, caring for a spouse, child, or parent with a serious health condition, or managing the employee's own serious health condition. Additionally, FMLA provides special provisions for military families, allowing leave for certain situations related to a family member's active duty service. Employers have several obligations under FMLA. They must inform employees of their FMLA rights, provide eligibility notices within 5 business days of a leave request, and continue group health insurance coverage. They're also responsible for ensuring proper reinstatement of employees after their leave ends. It's important to note that some states have enacted additional FMLA-related protections. For example, California extends leave eligibility to employers with as few as 5 employees and includes a broader definition of family members. New York, New Jersey, and Rhode Island offer paid family leave programs. Employees should check their state laws to understand any additional rights beyond federal FMLA. If an employer violates FMLA regulations, employees have the right to file a complaint with the Wage and Hour Division of the Department of Labor or pursue legal action. Common violations include refusing valid leave requests, retaliating against employees for taking FMLA leave, or incorrectly classifying workers as ineligible. Remedies for violations may include job reinstatement, back pay, and coverage of attorney's fees. Understanding FMLA requirements is crucial for both employees and employers. While the Act provides important protections, it's complex and can vary based on individual circumstances and state laws. If you're unsure about your rights or obligations under FMLA, it's advisable to consult with a qualified employment law attorney or human resources professional.